From the Library of Congress in Washington, D.C.
Good afternoon. My name is Roberta Schaefer, and I have the absolute pleasure and honor of serving as the 24th Law Librarian of Congress, and I'm also delighted to be convening this commemoration today of Constitution Day. For those of you who are concerned that something has happened to your calendars or your clocks on your iPhones, it is true that Constitution Day normally would occur to mark the day that the Constitutional Convention ended in 1787 in Philadelphia, and that would be the 17th of September. But the 17th falls on a Saturday this year, and so as such, the Law Library of Congress, which always takes responsibility for celebrating the Constitution on behalf of the Library of Congress, has decided that we will elongate the celebration because nobody can celebrate the Constitution too much. But we're not going to overdo it, I promise you. So we're going to start today, and we're going to end the celebration on September 26th at noon in the Pickford Theater, where we will show a very, very poignant documentary film called Last Day of Freedom, and a documentary film that I will tell you about in a few minutes. But we will also be showing this same film, Last Day of Freedom, today at 2 o'clock in the Law Library. So if you cannot come back on the 26th, or if you would like to see it today and possibly see it again on the 26th, you would be most welcomed at any time. So Constitution Day, September 17th, has only been celebrated since 2005. Even though the Constitution has been with us for a very long time. The day actually started out to commemorate Citizenship Day. Initially, in the 1930s, the late 1930s, Citizenship Day was created to honor new Americans. And William Randolph Hearst, the newspaper magnate, was very instrumental in promoting it through his newspaper chains. It was initially celebrated in May, and then in the 1950s, it was changed to be celebrated on the day that the Constitutional Convention finished, September 17th. And it wasn't until 2005 that Citizenship Day, which was that original idea that happened in the 1930s, and Constitution Day, celebrating the actual completion of the Constitutional Convention, were merged. So that is the history of Constitution Day. When Constitution Day was created in 2005, it was determined that every federal agency should find a way to celebrate the Constitution, but particularly that the Department of Education should reach out and help school children understand the content and the meaning of the Constitution. And as a result, little mini constitutions were created. And I have carried mine with me for many years, so much so that it has lost its cover. But I always have it with me. And I keep it in a very non-Library of Congress preservation casing, a sandwich bag. So I hope my colleagues in the preservation unit will not be upset with me that my Constitution is held in such high or low regard, depending on your standards. Now, why is it that the Law Library is so delighted to celebrate the Constitution? Well, of course, we are committed to constitutional ideals and the values of the rule of law, which our own Constitution and the Constitution of nations around the world embodies. We also our offices are also in the James Madison Memorial Building across the street. And as many of you know, James Madison is called the father of the Constitution, not only because he was so involved in the writing of the actual Constitution and of the Bill of Rights, But after the convention was over, he was an advocate for the ratification of the document, and he was very instrumental in the states and the people, therefore, ratifying our Constitution and giving us this living, wonderful document. We wanted to be in this room, however, so that you could look through the blinds and see the United States Supreme Court and have that in your minds as our program progressed. Now, today we are taking a bit of a different approach towards celebrating Constitution Day. In a sense, we're focusing on the Eighth Amendment of the Bill of Rights, which talks about not implementing excessive fines or excessive bail, but also addresses the issue of cruel and unusual punishment. In 2018, the Library of Congress intends to celebrate the 800th anniversary of the Charter of the Forest. That's a British document, as you can well imagine, since it's the 800th anniversary. Couldn't be part of our legal tradition. It's far too old. But nonetheless, we believe that the concept of cruel and unusual punishment emanates from the Charter of the Forest. So we're giving you a little bit of foreshadowing about a very exciting year that we will celebrate in 2018. But today, we have a very special guest, and I know that you can read his biography in the program, but I also want to thank Dr. Robert Maman for giving this talk today. At the 11th hour, we found it necessary to change our Constitution Day celebration agenda, and he very, very graciously agreed to step in and talk about a topic that is very near and dear to his heart, and that is mental illness. Just this past Monday, there was an editorial in the New York Times citing the fact that 40 million Americans, or 20% of our population, suffers from some aspect of mental illness. And Dr. Maman will talk to us today about the confluence of the criminal justice system and the mentally ill. So without further ado, it's my honor and privilege to turn the podium over to Dr. Robert Maman.
Good afternoon. I would talk about mental health courts, which is a rather new concept dating from the 1990s. Mental health courts have been developed to create a special procedure where mentally ill offenders charged with criminal activities would be diverted from correctional facilities to community mental health-based care. Thank you. The shared goal of the mental health court are to improve public safety by reducing recidivism, improving the quality of life of people with mental illness by increasing their participation in effective treatment, and reducing court and correctional-related costs. This philosophical point of view is not new, as it follows several approaches, including crisis intervention teams, jail diversion programs, specialized probation and parole caseloads developed to address the significant overrepresentation of people with mental illness in the criminal justice system. The estimates brings the percentage of prison inmates with serious mental illness to 20%, therefore triggering a reading of the Estelle v. Gamble from 1976, where the Supreme Court determined that the Eighth Amendment requires that prison officials provide a system of adequate medical care, including mental health care. Any novel approach to address crime in the United States is worth considering, as the U.S. continues to have the highest incarceration rate in the world, with 5% of the population, but nearly 25% of the world's inmates. Looking at the history, it seems that the recent shift in the correctional population under incarceration started with the reduction in the number of beds available in the state's psychiatric network. The deinstitutionalization of people with severe mental illness began in the mid-1950s, around the time when the first potent antipsychotic medication, named Thorazine, became available in the United States. The deinstitutionalization was accelerated in the mid-1960s in connection with federal incentives and court decisions. This process led to the disappearance of more than 90% of the state psychiatric beds for long-term care in the U.S. The advocate of deinstitutionalization believed that the closing of state hospitals would encourage the mentally ill population to live more independently in the community, while treatment would be provided by community health programs. Unfortunately, the federal government did not provide sufficient funds for community programs to meet the increased demand for services, and the state were not able to fill the financial gap. As a result of this lack of service availability, hundreds of thousands of mentally ill released in the community did not have access to treatment. These individuals were involved in substance abuse and misdemeanors, and they ended serving time in our jails and prisons, with a remarkable increase of the mentally ill population behind bars. It is important to realize that mentally ill individuals are known to be ostracized and stigmatized by other inmates, adding to the suffering related to their illness. And this additional awareness certainly justifies mental health court existence, at least in part. The first experiment took place in the 1980s when Judge Evan D. Goodman helped establish a court dealing with mentally ill offenders at Wishart Memorial Hospital in Indianapolis, Indiana. In this first setting, the criminal charges were put on hold, and the treatment providers sought a civil commitment, sending those patients to psychiatric treatment. Judge Goodman remained involved by scheduling periodic hearings to follow the progress of those patients. Eventually, the criminal charges were dismissed, but the patient remained under civil commitment. Those civil commitments could have been received through inpatient treatment as well as outpatient care. This experiment was eventually dissolved in the 1980s. But fortunately, only a few years later, in 1996, a number of various mental health workers who had been involved with Judge Goodman started a new mental health court program with the support of the local authorities in Marion County, where this new program was taking place. Shortly after this creation, other programs were initiated in Broward County, Florida, overseen by Judge Ginger Lerner Wren in 1997, and a couple of years later, Anchorage, Alaska, San Bernardino, California, had their own mental health court. From 4 mental health courts in 1997, the number has grown to more than 300 at present, and the number keeps growing. Looking at the making and functioning of mental health court, I want just to mention that in the fall of last year, I was very fortunate to be invited to serve as special advisor to the Montgomery County Mental Health Court Planning and Implementation Task Force. Present in the task force were judges, defense attorneys, prosecutors, mental health crisis service coordinators, rehabilitation service administrators, local correction administrators, family services, police and sheriff office staff, showing that the chair of the task force, a gentleman named Phil Andrews, had done his homework in putting together such a comprehensive professional team. One of the most remarkable features of the court is that they are closely connected to the name of a local judge as the main motto of their creation in most jurisdictions. In fact, it is essential that the judge involved in each court remain the same person in order for the court to develop a personal relationship with the mentally ill offender. During the status hearings, this judge that the participant knows will have to develop a relationship with this participant to give a stronger meaning to various rewards provided for adherence to the condition of participation, but also sanctions for non-adherence in order to ensure an ongoing interaction between participant and the court team members. Essentially, the judge accepts the role of becoming a social worker involved in the treatment team. And that's a big step, and the judge has to express an interest and the will and courage to be able to fulfill that role. In each jurisdiction, the court has its specific requirements, but must have at least 4 common characteristics. The first one is that each defendant will receive the customized rehabilitation and treatment plan to address his or her situation. Number 2, the treatment plan will be implemented by a multidisciplinary team of professionals having legal, correctional, and medical expertise. Number 3, as I mentioned earlier, regular status hearing at which treatment plans and other conditions are periodically reviewed for appropriateness will be scheduled, and those status hearings where the judge's role is so important in his relationship with the participant. Number 4, the criteria defining the participant complaints have to be provided and have to be clear. The participant offenders under consideration are usually screened early in the criminal process. They can be referred to the court's attention by pre-trial service officers, social workers, public defender's office, but also by jail officers and by their own family, as well as among others. the time between the arrest and the placement under the court jurisdiction is an important measure of the effectiveness of the court mandate. Each court has to create the list of criteria which will be used to select the offenders likely to be considered, and then those candidates will be given a more comprehensive assessment to determine their interest in participating in the program and to review the specific mental illness that they present with, as well as their individual needs in the community. These initial acceptance criteria will define which type of mental illness, crime committed, and criminal history are likely to be accepted by each court. Regarding mental illness, the trend seems to be limited to people suffering from what we call as mental health providers, serious mental illness, which was categorized under Axis 1 pathology in the DSM classification. Those serious mental illness diagnoses consist essentially in schizophrenia, bipolar disorder, major depression, as well as anxiety. And it is important to make a difference between this pathology and what was called an Axis 2 pathology in the DSM-4 manual, which was referring to personality disorders. The belief is still, I believe, that people with this major mental illness have less control or even no control on their behavior, and that in opposition to the personality disorder patient or clients. But there are two remarks. The first one is that this early distinction in control or lack of such, depending on the diagnosis given, this early distinction is now challenged by recent findings where functional brain imagings are showing some remarkable difference in the brain of individuals suffering from personality disorder versus individuals with no mental illness. So in light of such findings, the question of whether those individuals with personality disorder have control of their behavior becomes more and more, provide a more and more cloudy answer because more scientific medical data obtained show the abnormality of the brain function. Another element which is worth mentioning is that this very practical DSM-4 classification of Axis 1 and Axis 2 of personality disorder is now removed because a new DSM, which is a diagnosis, stands for Diagnostic and Statistical Manual of Mental Disorder. This new classification does not have those axes anymore. So the realm of mental illness is becoming more and more cloudy, at least to me. It is interesting to know that a study of 2005 in Broward County, Florida, found that the participant in the mental health court carried diagnosis of schizophrenia in 17% of the case, major depression in 40% of the case, and bipolar disorder in 24% of the cases. Beside after this number one element of the mental illness which should be considered, the court look at the type of relevant criminal activity which would seem appropriate for them to accept in the participant in the program. Most of the court started by accepting misdemeanors and public nuisance crimes. Also, beside this, the court decision of choosing which crime it wants to address, there is also a jurisdictional limitation of the court could be coming into question. For example, a court that operates within a municipal court will have jurisdiction primarily over misdemeanor charges. So all those elements have to be taken into consideration and explain the differences between each court functioning and criteria of functioning. Misdemeanor crimes are the least likely to trigger a strong affective response in the lay population or even among the various workers involved in the court system. On the other hand, crimes of domestic violence or felonies would be more likely to trigger anger and hatred in the mind of outsiders. And the lay people would have difficulties to accept the core, more therapeutic approach as meaningful. Nevertheless, once the philosophy of the court concept has been understood and accepted, one could very well argue that once this basic concept is accepted, one could very well argue for the incorporation of the felonies among the accepted criminal activities. For example, people who have exercised violence toward others, such act could be part of the mechanism of defense in a paranoia, and therefore resulting directly from the mental illness of paranoid delusions with persecutory features. But that is an ongoing debate. It is interesting to note that in the 2005 study of first and second generation court, 4 out of the 6 first generation court which has been reviewed started with accepting only misdemeanors, and that those 4 out of the 6 have been moving in the direction of accepting felony offenses on a case-by-case basis. In the same study, the second generation court, the 7 of them which were studies, all of them showed an acceptance of felony charges for consideration among their participants. After the mental illness and the criminal behavior, the offender's criminal history is also relevant in considering the participant's acceptance, the offender's acceptance. Multiple variations exist in the acceptance criteria scheme. One of them is whether the court believes that a causal relationship must exist between the individual's mental illness and the crime committed. And that is one of many issues where the team involved must have the various legal and mental health professionals come to an agreement in a selection process. Ultimately, the judge has the final say over the case, but the court team approach is unique and essential to the court function. A lot of difficulties remain Two of them that I want to cite here. The first one is that the aftercare is essential to the success of the process. The court intervention and crime prevention would not be effective short of providing the mentally ill offender with some form of income, job training, day program activities, or living arrangement. Also important, and I would say essential, is the availability of public funds to provide additional staff and provide training for the staff involved. Also, some criticism which have been voiced. Some have criticized the court for focusing on misdemeanor offender who would have received a shorter sentence of jail or probation if not for the court involvement. So the issue is certainly relevant to each case. Also, other critics raised concern over the possibility that court would coerce people into treatment, as well as the fact that some courts require the defendant to enter a guilty plea in order to be considered a candidate by the court. Also, the issue of infringement on the privacy of treatment information is raised. Finally, among the one I'm quoting today, of concern the fact that some ineffective mental health community network, unable to absorb the number of referrals from the court, would limit the benefits of the whole system in that jurisdiction. In terms of the outcome, the post-discharge reviews have confirmed a reduced level of criminality, but recidivism still exists. And each new case would have to be reviewed and for the court to decide if the new crime committed by this known offender qualify for return in the mental health court or for more traditional handling. Some studies, although they didn't provide me with specific numbers, showed in an urban institute evaluation in 2 New York City courts, a significant reduction of recidivism. In conclusion, the courts are part of the new judicial philosophy, where specialized courts have shown a more comprehensive way to deliver justice, keeping in mind the societal need for rehabilitation of the offenders, as domestic violence court do, or drug court do. And finally, and I'm very happy to raise this issue at the level of Congress, because that's an important element of this new concept. Data collection is essential in allowing the revision and improvement of services delivered through the court and support justification of the investment of public funds in the system. Thank you for your patience.
Thanks very much for the talk. Now, I'm left wondering. I know you said something about how participants in the program are moved into the program, but I'm still left wondering. My anticipation is that a defense attorney will counsel against Even a public defender may counsel a participant against participation in the mental health court because the treatment will be longer maybe than otherwise. And the client himself may say, well, I don't really want to be in the system that long. And so there must be, I mean, it sounds like there are big due process issues that are hiding behind that moment where we move from the traditional system to the mental health court. Can you say more about that?
Yeah, that's a very good question, and that is certainly one of the issues which was raised when I was involved in the task force. This was raised by the public defenders and understandably. But there's also the philosophy in the acceptance that those individuals are misbehaving with criminal activities of all type because they don't receive sufficient mental health treatment. And, in the same way that we would not have any difficulty, any of us here, to accept the fact that if we hear about a diabetic who is acting out, we would all accept the idea that we better give him a shot of insulin, and force it if we need to, rather than let him be and argue freedom, independence, more than, it's a bit fatherly approach, but it can be certainly, it makes a lot of sense in terms of community philosophy. And that debate certainly goes on, and voices are expressed from both sides of the aisle on this. Thank you.
Dr. Maman, do we know about is there a difference in the age group of these criminal offenders that are being...
I did not look into this specific. It's a very interesting point, but I was more looking at the global presentation, but I suspect that all age group would be involved because those are lifelong illnesses, and therefore, misbehavior at any age would be possible, if not almost expected, on the big numbers. So that's what my response to that.
Thank you.
In terms of, if I could come back to the first part, I had an interesting anecdote. I was at the forensic annual meeting, and a group from England, I think, presented a case where this father of 3 or 2 kids, developed thoughts of pedophilic nature. And I don't recall whether he acted on it, but there was some suspicion, and eventually he was charged, he received a sentence, but it was no, the sentence was limited, let's say. The wife, of course, left, divorced, the kids were gone, and then he got a headache. And the studies by the radiologists found a tumor in the brain, and they removed the tumor. And then he didn't have any pedophilic thoughts, and he cleared up. I don't know how the process worked, but nevertheless, he was released. The wife came back, kids came back, everything was nice. And then a few months later, or years later, I forgot, this was presented 6 or 7 years ago at the convention. He told his wife, honey, I have those thoughts about those kids. And then he had another study, and sure enough, he had the recidivism of his brain tumor. So, and that's where the question is of whether, in that case, it was accepted that the behavior was related to an organic pathology, therefore the control was null or non-existent from the subject. Then the question is raised if the reason is raised that do the other offenders suffering from mental illness have much of a control on their behavior. But it's such a murky place because although that would maybe raises a lot of questions, and the answer could be difficult, costly, and socially difficult to accept. So that's the debate going on.
I was intrigued by your mentioning that there's a kind of an activism and almost a social worker kind of an approach taken by the judge. And of course, in the American system, that's antithetical to how judges usually are told to act and actually act. There's supposed to be an aloofness and a distance from the parties. And I'm wondering if one thinks about that, have these mental health courts thought about mediation or using systems that are not purely in the judicial vein? Because in a sense, it sounds like we're really asking our judges, forgive me for using your term of art, to be schizophrenic. When they're in a traditional court, to be aloof and distant and not involved with the parties, and when they're sitting on the bench in a mental health arena, to be paternalistic or parental and all of that. I'm just wondering if some of the programs have looked at mediation or an alternate way of assigning potential participants.
Well, but mental health court, without using the term of mediation, are doing that exactly. So and that's why there's a need for a consensus, an acceptance that treatment is needed. So this mediation philosophy is certainly put into a direct application in the mental health court, and that is the reason why the judge of the specific jurisdiction must express interest in moving or carrying 2 or 3 hats, or maybe more, to get involved in those cases, and that certainly shows the acceptance of the paternalistic view that treatment will be more beneficial than just punishment, and leaving these individuals to their own choices. And, being in the medical field, I am not offended by the concept. But, I can understand that the legal minds can have some difficulties.
Hi, thank you. How are the HIPAA protections?
Pardon?
The HIPAA laws?
Yeah.
If the court record is public record, how are the HIPAA protections secured for these participants?
I do not have the answer, but certainly the question, the issue, has been raised and is relevant to be looked at, and unfortunately, I didn't go in that side of the problem, but that's one of many which have to be, cooked into this rather new process. We talk about barely more than 20 years. So, but that's also a major element which has to be looked at and taken into consideration.
Question over here? No? Any more? No? Okay.
Hello.
Hello.
So we've talked a little bit about the rights of someone with a mental illness as either an unusual or a cruel punishment, but are there any other rights for people who have a mental illness, but that classified as a disability? that you've considered or you looked at or you have had to work with specifically?
I'm sorry, I didn't hear the few.
Oh, sure. So we talked a little bit about so the ethics behind ruling on someone with a mental illness, but have you talked about or researched a mental illness as a disability and looked at the ethics and the constitutionality behind that? So looking at mental illness as a disability.
Okay. I am not
Disability
sure
rights
that,
in relation to this?
We are my understanding is that the disability resulting from mental illness does not make you incompetent in the eyes of the court. So if you are competent of your behavior, regardless of your disability, then you are a defendant who has to face the charges filed against you. So I think the disability issue would be relevant after the resolution of the legal question, and that's how I understand it. Now, when disability reaches the level of incompetence, then the traditional court have handled that through NCR with the defendant attorney pleading NCR and the patient going through a forensic evaluation as to ability to stand trial or competency to, or responsibility of the criminal behavior. So those elements, those avenues have already in a system. So that's not just an additional one, which doesn't go to the assessment to the incompetence as far as the incompetence status.
What about people with disabilities that don't have a mental illness? People that are deaf, for instance, how will they be treated?
I think that that's a very good question. It's a very good, very interesting issue, and there's a psychiatric facet to the question and to the issue, but not one that I have explored at this time, but certainly relevant to the topic and interesting to look at, certainly. Thank you.
Dr. Maman, thank you so much for giving us a bit of a different approach to celebrating Constitution Day. I hope everyone has now come away with the idea that it is not only the Supreme Court, but it is other courts that are actually fully responsible for maintaining our rights within the constitutional framework, and that I think the intent of marrying Constitution Day with Citizenship Day was in fact to make sure that every citizen assumes his or her role in protecting the Constitution, not just the courts and certainly not just the highest court, which inspires us here today, but is not the only way that the Constitution continues to live and have relevance to everyday life. Thank you so much for participating. We have some gifts for Dr. Maman. Okay. Both of these? Yes. So he's getting a gift as a lawyer and a gift as a doctor, I suppose. Thank you.
Thank you. I will gladly come back if you want.
And please now join us for a reception at the back of the room. And if you are able, at 2 o'clock, please join us in the Law Library, which is the Madison Building, room 201, for a showing of the film Last Day of Freedom. I think it has enormous relevance to a number of topics that were touched upon today, and it is, in fact, just a beautiful but difficult documentary. So thank you for being here today. Go out and celebrate the Constitution today and every day, and please join us for the reception at the back of the room. Thank you, Dr. Maman.
This has been a presentation of the Library of Congress. Visit us at loc.gov.